Good afternoon, sir. Good afternoon, everyone. I am Alison Greenwich Cera, and today I am going to discuss the following. First is the manners of appraisal and Article 1787 and Article 1788. Second is the essence of partnership and the cases covered of the liability for damage and interest. And last, capitalist partner versus industrial partner and Article 1789. Article 1787 states that when the capital or a part thereof which a partner is bound to contribute consists of goods, their appraisal must be made in the manner prescribed in the contract of partnership, and in the absence of stipulation, it shall be made by experts chosen by partners and according to current prices, the subsequent changes thereof being for account of the partnership. So before I discuss to you what Article 1787 is, I'd like to explain first what appraisal is and how it works. So ang gagawin ko na lang example is the home appraisal since generally appraisal is done by the banks when somebody is buying a property to determine its current value. So every house is unique. Meron tayong mga appraiser that is trained and licensed for expertise in putting value on properties. So basically, appraisers don't work for the buyers or seller. Their primary goal is to actually protect lenders like banks or financial institutions who's lending their money for the home's value. In appraisal, we have to weigh factors about the property or location, including the size, condition, and comparable properties to appraise its current value. So appraisers know how to focus on condition that affects the value. Appraisal lowers the proposed purchase price and can affect transaction details like the seller might actually lower the price or the buyer might increase the down payment. In conclusion, appraisal is the valuation of a particular property's worth. Balik na tayo sa Article 1787. So, etong article na to, it is a very familiar concept for us. Why? Because during our accounting for partnership and corporation subject, when we are going to form a partnership, yung mga partners or yung mga parties, pag magpo-form na ng partnership, ina-account natin magkano yung mga assets or liabilities na ipapasok natin sa partnership. Ina-account natin yung mga value nila. So, yung pag-account natin sa values nila, which is yung asset na na-acquire ng partnership or liabilities nito is may hierarchy system. So, ano yung hierarchy na yun? First, sinabi dito na their appraisal must be made in the manners prescribed in the contract of partnership, meaning it is the agreement of partners or yung kanilang agreed values. Second is, in the absence of stipulation, it shall be made by experts chosen by partners and according to current prices, the subsequent changes thereof being for account of the partnership. So now, in the absence of agreed values, yung magiging basis is yung kanilang fair value or its current price. So basically, that is what Article 1787 is. So ang rationale ng law na to is in order to know the monetary value of the contribution of that partner as of the date of contribution. Useful ito in the future operation of the partnership, just like in accounting of the share of profit or loss of every partner. So, under din sa law na to, in the absence of stipulation, the share of each partner in the profit of losses and losses shall be in proportion to what he may have contributed. Next, we have the manner of appraisal of goods and their property contributed. The appraisal of the value of the goods contributed is necessary to determine how much has been contributed by the partner. So first we have is by stipulation or as prescribed by the contract of partnership. So depende kung ano yung nakalagay sa contract of partnership. For example, we assume that partnership agreement provides for the decision of profit and losses in the ratio of original capital investment. So sa A and B partnership, ang original investment ni A is 400,000 and B has 800,000 respectively. So, kunwari, lumabas sa income summary nila na meron silang 300,000 income. Yung distribution ng profit ni A and B ay magbe-base sa naging agreement ng both parties. So, A will have 100,000 and B will have 200,000. Second is we have in the absence of the stipulation, meaning walang pinagkasunduan. The share in the profit and losses in their operation is in proportion to what he have contributed. Ito na yung contributed capital or the original beginning contributed capital at the year of the partnership formation. So kapag walang nakapagsunduan in the share of profit and loss ratio, nagiging mahalaga yung contributed capital kasi yun yung magde-determine kung ano yung magiging share ng partners sa kanilang profit and loss. Then, by expert chosen by partners according to current price. So, first is kung ano yung pinagkasunduan ng partnership, di ba? Or the agreed value. So, in the absence of the agreed value, the law stated na yung mga partners, pwede silang kumuha ng mga experts and that experts will be the one who will determine the value of the assets and liabilities based on the current price or the fair value. Next, we have Article 1788. A partner who has undertaken to contribute a sum of money, so money naman yung contribution, and fails to do so becomes a debtor for the interest and damages from the time he should have complied with the obligations. Second paragraph. The same rule applies to any amount he may have taken from the partnership coffers, and his liability shall begin from the time he converted the amount to his own use. So in this case, sa first paragraph, it talks about the promise of contribution. Naging debtor siya in the nature. Debtor siya kasi kailangan niyang mag-contribute ng pera to creditor partnership. Debtor din siya kasi may obligation siya to contribute. And sa second paragraph naman, the partnership is already existing. Tapos, etong si partner is nangutang kay partnership. Kasi di ba we all know that partnership has a separate juridical entity that is distinct to the owners or partners. So, because of that, pwedeng mangutang ang partner from the partnership or yung loan partners. Nangutang si partner kay partnership in this nature. Naging debtor siya by nature si partner ng partnership. So, what does it pertain? It is the obligation with respect to contribution of money and money converted to personal use. So, under this obligation, it will be the duty to reimburse any amount that the partner may have taken from the partnership coffers and convert it to his personal use. The partner will be liable for that amount and the liability begins from the time he converted the amount to his personal use. Pero take note na the right of partnership in this case is Yung partnership, entitled lang siya to demand only the amount converted and the interest and the damages, but the partnership cannot avail the profits derived by the partner from the use of converted funds. Essence of partnership. It is a settled rule that when a partner who has undertaken to contribute a sum of money fails to do so, he becomes a debtor of partnership for whatever he may have promised to contribute and for interest and damages from the time he should have complied with his obligation. Being a contract of partnership, each partner must share in the profit and losses of the venture. So, this is the essence of partnership. So, ano yung pinipertain nito? Obligations with respect to contribution of money and money converted to personal use. Yung obligation niya is first, mag-contribute ng pera sa common fund, and second, kapag ang obligation niya is nangutang naman siya sa partnership. Cases covered of the liability for damages and interest. First, money promised by a partner is not given on time. So, to contribute on the date fixed, the amount he has undertaken to contribute to the partnership. So, kung kailan pinagkasunduan na ibigay niya yung kanyang contribution, he has the duty or he has the obligation to fulfill it. Second, money of the partnership is converted to partner's own use. So, to reimburse any amount he may have taken from the partnership coffers and convert to his personal use. Ito naman, nangutang siya kay partnership and kailangan niyang bayaran yung utang niya kay partnership to pay for the agreed or the legal interest if he fails to pay his contribution on time. In case he takes any amount from his common funds and convert it to his own use, ibig sabihin si partner kailangan niyang ibigay yung kanyang contribution pero hindi niya naibigay or na-contribute to the specific date and later on niya pa mabibigay yon, so nag-accord na yon ng interest because of the delay to compensate for the lost value of money. On the other hand naman, pag nangungutang tayo, which is a formal debts like sa banks or financial institution, from the date na nangutang tayo, nag-i-start na siya magkaroon ng interest until mabayaran na natin yung utang na yun. So next we have Article 1789. An industrial partner cannot engage in business for himself unless the partnership expressly permits him to do so. And if he should do so, the capitalist partner may either exclude him from the firm or avail themselves of the benefits which he may have obtained in the violation of this provision with the right to damages in either cases. So, meaning, industrial partners, yung kino-contribute niya nga, di ba, is yung kanyang industry or labor to the common fund of the partnership. So, by the very nature of that, nakapaloob sa Article 1789 na industrial partners cannot engage in the business for himself, meaning his full attention should be on the partnership only and not on the other partnership. Kasi nga, di ba, hindi naman pera yung kino-contribute niya. What he is contributing is his service. But pwede naman siyang mag-venture sa ibang business as long as na may permission ng ibang partners. But if not, he cannot engage. So, for example, the partner didn't allow the rule and he didn't follow the rule and he decided to have venture to another business kahit na may partnership na sila without the express permission of the partners. So, ano mangyayari? Kahit na same line ng business yan, kapag walang permission to the partnership, he cannot engage or prohibited siya to do so. So the consequences of industrial partners engaged in any business is first, he can be excluded from the partnership, meaning tatanggalin siya sa partnership. Or second, hindi siya matatanggal, maintain pa rin siya, pero the capitalist partner may have the right to avail of the benefits he obtained from the business from other business. Meaning, pwedeng kunin yung ng capitalist partners kung ano yung kanyang kinita from the other business he ventured. Capitalist partners can demand because dapat yung focus or faithfulness ni industrial partner is nasa partnership lang unless otherwise stipulated. In either case naman, the capitalist partner may have the right to file an action for damages against the industrial partners kasi meron siyang nilabag na batas or agreement. So next, we have capitalist partner versus industrial partner. So as to their contribution, so alam naman natin lahat na ang capitalist partners are those who contribute money or property or both money and property to the common fund. And ang industrial partner are those who contribute their industry or labor to common fund. It can be mental or physical. So industrial partners cannot contribute capital unless stipulated. So next is the prohibition to engage in other business. In capitalist partner, he cannot engage with the same kind of business with the partnership. So take note, with the same kind lang. But if other kinds, like for example, clothing line yung kanilang business, tas gusto niya mag-venture ng capital to other business, which is food business, pwede yun kasi other type of business yun. Pero bawal siya mag-engage in other business with the same kind ng partnership unless there is a stipulation authorizing him, ibig sabihin, he is permitted to do so. So, kapag si industrial partner naman, he cannot engage himself in business with either the same line or not the same line of business with the partnership. Ang exemption niya is unless partnership is expressly permits him to do so. So, kay industrial partner, kahit na same line ng business yan, kahit iba or kahit ibang line ng business. Like for example, yung partnership nila is nasa line ng food business, tas yung i-venture niya is nasa clothing. Kahit magkaiba ng line yan, kapag wala siyang express permission from the partnership, he cannot engage himself in that business. He is prohibited kasi industrial partners are prohibited to engage themselves with the same business kasi baka i-apply niya kung anong ginagawa niya sa partnership to other business. Industrial partners should be faithful to the partnership unless otherwise stipulated. So it is not detrimental to the part of the partnership and will not be unfair to other parties. It is also to prevent a conflict of interest and to ensure compliance by industrial partners who must devote his time to the partnership. Next, we have as to profit. So, the distribution of profits according to agreement. Kapag kay capitalist partner, if there is no agreement, it should be in the proportion to his contribution to the common fund. And kay industrial partner, if there is no agreement, he shall receive such share as may be just and equitable under the circumstances. And as to losses naman, the distribution of losses according to agreement. The losses shall be distributed in conformity with the agreement. However, if walang agreement kay capitalist partner, then the agreement to us to profit yung susundin. So, ang exemption niya, if the absence of agreement as to profit and losses should be in proportion to his contribution. And kapag kay industrial partner naman, and in the absence of agreement, yung industrial partner, hindi siya magiging liable for any losses of the firm. So, that's all. And Thank you for listening and have a good day.